Good evening.
Dr. Lamb, how are you?
Good. I don't know why it is every week when y'all start jumping off, it kicks me off, but I'm here. We're on time. So appreciate everybody being with us. And so let's get started. I'm excited for Dr. Griffin Jordan's presentation tonight, but I want to do a quick debrief from last week's case study. And not to reiterate the case, but hopefully what you learned came out of it is what kind of feeds us into tonight and our discussion board questions for last week. In this, we talked about due process and discipline. Well, this case study sets us up for that. And one thing I need for us to understand, the legal underpinning that students get due process in schools comes from 1969, the Tinker versus Des Moines case. Please say it, Des Moines. And that's the case that said a student's rights don't stop at the schoolhouse door. That's a direct quote. And so that's why prior to 1969, kids did not have due process rights. And I was in school a good while before then, and I remember just getting jerked up from time to time. Of course, I probably needed it, but there wasn't any of the protections that we have today, due process, and there was no restorative justice in terms of discipline and those things. So please remember that all the things that we do in the modern era came from 54 years ago in 1969, when the Supreme Court ruled in favor of Tinker versus Des Moines School Board. It was over a Vietnam War protest, but it established that kids get due process. And Dr. Griffin Jordan's going to talk about that. I had a couple of things that caught my eye this week. And so I want to make sure I address those in the answer. I see Neely's with us. Neely, thank you. Neely had a good one about adequate supervision when you have large crowds. I'll tell you, unfortunately, I know this from having to go to court too many times. The number is 1 to 45. So if you're supervising the cafeteria or a commons area or an auditorium or a gym or any of those things where you have a large congregation of students, the number for adequate supervision, according to the law, is 1 to 45. So if you've got 450 kids in your cafeteria at lunch, you need 10 adults on duty. You can't have, and this notion of, well, we've got this large common area outside of our cafeteria and kids can go out there and we don't have to supervise them. That's wrong. That's just dumb. That's the same thing as, oh, we push them out the door at 3:30 and lock it. We don't care what happens outside on our grounds. They're not, or parents set them out before 7 o'clock in the morning and that's on them. All of those are wrong. Let me say that again. All of those are wrong. As long as portal to portal, from the time that they get to the bus stop, at the bus stop, on the bus, at school, before and after school, doesn't matter. You got to provide adequate supervision, and that number is 1 to 45. And yes, and Amanda asked, do you have to do before and after school if they set them out or they don't come get them? Yes, the answer is yes, you do. And I think that was it. Remind you about Tinker versus Des Moines. All right, so I'm so excited. Dr. Griffin Jordan, it's all yours. Share your screen and jump right in.
All right, let's see. Oops. Okay, so welcome everyone. Happy Valentine's Day. I know this is the place that you would rather be more than anywhere else in the world, so I'm going to make sure that your time is well spent here. So thank you for coming. I see participants as 9 of us, including me and Dr. Lamb, so we're going to have a ball. I have a lot of information to cover. This was very useful for me to know, so I'm hoping that it helps you. I have a lot of practical scenarios and cases that we can go through. As I'm talking, every now and then I'll break, I'll say, questions, thoughts, or if I'm going, too fast, just unmute and just say what you want to say. If you have questions or if you have an experience that you want to share, please do. We all are in here, and if you're like me, I'm a lifelong learner. I learn continuously. So we're going to make this worth your while. So tonight, you're going to get an overview of the laws and policies as they relate to student rights and due processes in your school. It's important that you know that the discipline policies that your school follows, your principal didn't just sit over the weekend and just make them up and, you know, come up with a whole bunch of policies that had this nice flow to it. It came from somewhere. It kind of trickles down. It trickles down from the state to the LEA, to your school. So let me explain that. So we have a lot of different policy manuals, procedures manuals, and this is all derived from the state of North Carolina. I'm going to go first to the discipline data reporting. This is all the data okay, so it doesn't want to go. So let me find another way to do this. Okay, we'll do it this way. This is the North Carolina Discipline Data Reporting and Procedures Manual. Everything that has to do with discipline in the state is in this manual. It's a massive manual. As you will see, it gives you guidance for everything, for reporting incidents. It gives you guidance for participants in an incident, how you handle behaviors and different acts. You see all the different types of entering, how you enter objects and weapons and reporting consequences. Gives you guidance on seclusion and restraint. Everything is in anything that has to do with behavior and discipline is in this guide. So I'm going to scroll down a couple of pages. Let's see. Okay, so page 6. Remember that discipline infractions must be reported. You can't decide what you report and what you don't report. They all have to be reported. There are 9 that if you do report them over a 2-year span, it could lead to something like the loss of your job. It could lead to students being able to transfer to other schools that are safe because apparently yours might not be too safe. And then it could lead to something like the state coming in and deciding what they should do for your school. As you can see, the state board policy and the North Carolina general statute have been noted when laying out the requirements for the State Board of Education's policies, and you see them right here. So these are those 9. If you have schools, if you're in a school that has murders, kidnapping, sexual assaults, you've got to report it. Even though it could cost you, you can't not report it. Hopefully you won't ever be in that situation, but these are those 9 offenses that could get your school labeled persistently dangerous by the State Board of Education. So in addition to state policy, general statute, you also have the Office of Civil Rights. They collect data as well, and they have policies, and they follow federal laws and make sure that students with disabilities and different sexual orientation and different ethnic backgrounds are all treated fairly. Going down here, 7, page 7, what must be reported? Pretty much everything. You have to report ISS, out of school suspension, in school suspension, expulsion. We typically don't use expulsion. 365 days is a full year. That's usually the max that we'll follow. Regarding consequences, there are 16 offenses that must be reported to the North Carolina Department of Public Instruction within 5 school days. You see here. At my district, within the district, we're expected to report it within 24 to 48 hours, just depending on the severity. They don't mess around. If somebody brings a gun, can't wait 5 days to report it to the state. That's 24 hours. It needs to be reported. It comes before a lot of other things that you may have on your agenda. You have to put that at the top of your. So I'm not going to spend too much time. Just know that your district policies are derived from this state manual. This is where that's coming from. Let's see. Going down to Power School. Everybody knows about Power School. This is the document that tells you how to enter. This document we're looking at tells you how to enter incidents in Power School. There are system rules. There are required fields, such as your incident type, your incident date, the location, description. We'll get into the description a little bit later. The reporter, who actually reported it, who's the offender, what's the behavior, what's the action. And this is where Educator Handbook, if your district uses Educator Handbook, will come in handy. My district uses Educator Handbook. It's a third-party vendor that syncs with Power School. So all of the required fields in Educator's Handbook have been pre-populated, so you can't complete your report until you've completed all of the fields in Educator's Handbook. It won't even let you export it into Power School until you have finished. So that kind of ensures that you're not going to forget anything when you're doing your incident report, when you're doing your investigation. Everything's going to be included before you can actually hit that you're done. All right, so I'm going to go back. Okay, so that's the reporting data. Next, we have the State Board of Education Board Policy Manual. So what we just looked at was discipline. Now, this is your board policy. Let's see. And this is another massive document that encompasses all of the types of procedures that go into running a school system. You have a whole lot of, you start at A, you have a whole lot of policies, and then if you click on these policies, you have sub-policies. This right here is alternative learning programs. You have a question? Okay, alternative learning programs. And if you see, let me move this up. Give me a second. All right. If you see here, it gives you the different types of policies, the policy type, the category, and then the dates. It gives you all the information. You click here and it goes into the actual manual. Looking at one more, let's go down. This is Safe Schools. So remember, we just mentioned persistently dangerous schools definitions. We talked about what it was to be a persistently dangerous school. This is where it's coming from. This is the main education Bible. This is your board policy. So if you click on this, it talks about that particular policy. So if you notice, if you've ever looked in your district's code of conduct or, board policy, it looks something like this. They're kind of similar because your district is getting their information directly from the state. They have to. So you'll see, like, for instance, this is district's handbook. And if you go down, you have the dress code, you have emergency notifications, you have, let's see, weapons, sexual harassment, use of tobacco, all these things right here. It came from the state board policy. So I'm going to scoot on down to the code of conduct. So we've gone from the state, now we're at the LEA level. And you will notice, let's see, code of conduct. This came again from the state's policy. So you notice level 1, this is in-school interventions. If you have a level 1A, that has to be an in-school consequence. It cannot be an out-of-school suspension for level 1A. So you have plagiarism. If someone plagiarizes, if they use their phone when they're not supposed to, if they break dress code, if they have a minor disruptive behavior, or if they have attendance concerns, you can't suspend them out of school. There's a level 1B for secondary school, well, for elementary and secondary. I'm more familiar with the secondary. This is in-school intervention for the most part. There can be an out of school with level 1B only if there are aggravating factors. So if you have that same plagiarizing incident and the student plagiarized, then they need to do something in school. They might have to redo the assignment. They might have detention, something in school. Now, if the student plagiarizes 5 times, those are aggravating factors. Something else might have to be done. But for the most part, with your level 1s, unless, again, it's extreme and aggravating factors are involved, it has to be an in-school discipline consequence. And then, so we've done state, then we've done our LEA, which gets their code of conduct from the state. And then you go from your LEA to your individual school. And this is my school. So as you can see, I have some of the same, here's right here, page 7. The Durham Public School Student Code of Conduct. I didn't create it. This was already established from the district. So on page 7, let's see, 7. Durham Public School Student Code of Conduct, Board Policy. I didn't recreate the wheel. I cut and paste it. It's the same thing. If you look at mine and you look at the districts, the same thing. You've got to be consistent. You've got to have a team that's consistent. You can't make it up. Make sure your policies are in line with your districts, and your district needs to make sure their policies listed are aligned with the state. So with all these entities, remember that the State Board of Education sets the policies. The Department of Public Instruction interprets and actually enforces the laws and the policies. And then you have the LEA, who creates the code of conduct with consequences. And then you have your school level that has the in-school type of consequences that are governed by the district, your school district. So as I mentioned at the beginning, it is kind of like a trickle down, starting from the state. Everything should kind of be balanced out and be the same. Okay, any questions so far? Okay, so those are all of those that we've just discussed. All right.
Dr. Griffin Jordan, before we go any further, I want to reiterate 2 things. What Dr. Griffin Jordan just explained to you, and you know, this is kind of one of these write it down things. The state says what the infractions are. The local board says what the punishment or consequences for those infractions are. And the reason why I want to highlight that, I had one of the groups in the other section said, well, We don't like what the handbook said in terms of the punishment for this infraction. Maybe the faculty ought to get together and rewrite the handbook. And I was like, wait, time out. No. So I want you to understand the governance piece that Dr. Griffin Jordan just said to you. For some reason, it didn't kick in with that group that you don't get to change the consequences. The state sets what the infractions are. Cannot do this in our school. The local school board adopts the code of conduct, and it's passed in to schools. That's the governance model. You can't change that. Don't even think that that's within your purview. That would be a no. And the other thing I want to make sure we understand, we have to report incidents, not outcomes, in Power School and to the police. So don't be that nitwit that thinks, well, if I don't suspend that kid, I don't have to report. You have to report what happens, not what happened as a result of. That's one of the things that happens every day. Another one yesterday. Principal fires. And they said, well, why in the world didn't she report that? And she claimed, well, I didn't do this, that. Why didn't she report it? Well, Dr. Griffin Jordan pointed that out to start with. Because of that persistently dangerous statute from the federal government, from No Child Left Behind, if you report these things, you can lose your job. So what people are doing, they're gambling. They're just like the Myers Park case. Nothing to see here. All those reports of sexual assault and violence on their campus, well, they're not going to be even-handed or neutral when they're out investigating. They're going to find what's most best for them. That's why anything sexual, you're supposed to call the law first, because they'll be fair and impartial. You can't be, because there's consequences for you. But another principal yesterday was fired. It's every day now for not reporting, because I'll get in trouble if I report. So you got to understand, you got to report, good or bad, you got to tell it. And you don't just say, well, if I don't assign a consequence to that, if I don't suspend them, I don't have to. You have to report what happened. Even if you don't do anything, you still have to report what happened. And I'm not just talking about crimes and violence. I'm talking about that whole list of infractions. Every one of them, you got to put in Power School. And don't claim that we've got this third party vendor that we run stuff through so we don't have to. That's against the law.
So I don't understand. I mean, if you're in trouble if you do, or you're in trouble if you don't.
That's correct. But the difference is the trouble if you do report, you can survive that. The trouble if you don't, you'll get sued. That's what we're talking about, tort liability. Okay. If you didn't report it, they're coming after you. They're coming after you as an individual to take your house. Okay. That's the difference. People say, well, why should I report? If I report, I'm probably surely going to get in trouble. Well, if I don't, I'll take the risk. But now you're only, that there's mitigating factors of things that can happen. But if you don't report and you go to court, they're suing you as the individual. That's why you need to report. I mean, if you like gambling and at really bad odds, this is a deal for you. But if you don't like gambling, and especially when the house is tilted about 99-1 against you, then you better report. Yeah, bad things can happen if you have them, but we're going to talk about how you can kind of prevent some of those bad things. But yeah, they're asking you to tell on yourself. But again, on the sexual stuff, you've got to recuse yourself, because you're not going to be. It's hard to be even-handed. You got to recuse yourself. You got to call the police and let them initiate the investigation. Dr. Griffin Jordan, pardon my interruption, but I wanted to hit that. I wanted to make sure that we understood those 2 points. We had kind of a gap in communication last week where folks didn't really understand that governance piece. We've also got a gap where people think I can cover this up, or if I don't suspend, I don't have to tell. Neither of those are true.
Yes. Like Dr. Lamb said, you're likely going to get in trouble, but I'd rather just, for those persistently dangerous situations, I'd rather report, take the chance that I lose my job and have to find another one, than to not report, lose my job, and then lose all my money, my house, and everything else. So, you've got to weigh it. and just make the right decisions. Okay, so now we're going to move on to get into due process a little bit more, hoping that you'll kind of understand it just a little bit more. There were several articles that I saw. I just grabbed two, and I want to share them with you. The Southern Poverty Law Center does a lot of work down south with due process rights of minority, indigenous people, people that tend to not have a fair shake in the legal system, and they support them. So in this first article, the SPLC, Southern Poverty Law Center, sues an Alabama school district for violating students' due process. All right, so they have a student named Andre. Of course, this is not his real name because he was underage. And his friend were taking turns on a cell phone playing a video game called Last Day on Earth Survival, about staying alive in a zombie-infested planet when a real-life gunshot rang out at school. The teenagers, who were students at Robert E. Lee High School in Montgomery, Alabama, rushed out of the school's gymnasium with their peers. When they reached the parking lot with the other students, Andre's friend gave his cell phone back to him. Video surveillance captured the exchange, and the boys were accused of possessing a handgun. They were each taken into custody, interrogated overnight without a parent or lawyer in the room, and expelled from school. Even after the boys were acquitted in juvenile court, they were not allowed to return to school. This really happened. Andre entered an alternative school that will not allow him to earn enough credits to enter the 11th grade, meaning that he would have to repeat 10th grade if he returned to Montgomery Public Schools. His friend is currently pursuing a GED diploma. The SPLC filed 2 lawsuits against Montgomery County Board of Education on the grounds that it violated the boys' due process rights under the 14th Amendment of the U.S. Constitution. Allegations of misconduct damaged students' educational and employment opportunities. This is why 45 years ago, the United States Supreme Court held that a student's public education must be protected by due process to help ensure fair and just outcomes for students, says one of the SPLC attorneys. So in the lawsuit that they filed, the students were seeking a court order to reverse the school board's decision and immediately reinstate them in the Montgomery County schools because they had been expelled. They also wanted a correction to their academic record. And they also wanted the school district to reform its disciplinary policies and practices and compensate them for missed instructional time. So this is one incident where the school system, they were wrong. Number one, what type of due process was held? You took these 2 students because of a video footage that showed them exchanging something. You say they had the gun, you expel them, no gun was found. Apparently there's witnesses that says they were in the classroom and went out to the parking lot with the class. So how could they have been in the distance or wherever firing the gun? There are a lot of different things that you can tell that the school did not do its due diligence in investigating and doing their witness statements, writing up the proof. There's no proof. So this is one case where, and I looked to see if I could find something to see if the principal or someone lost their job, and I couldn't find it. So that is something that I'm going to kind of look back on this. This only happened a couple years ago to find out what else happened with this. But make sure if you're going to accuse a student, make sure you have proof and make sure the student has had a chance to give their side of the story. You've got to listen to all parties. It's very important. They didn't listen to anybody, apparently. The second one, FSUS, this is Florida State University Schools. It's a public charter school. Now, remember, charter schools are public schools. So they have to follow the North Carolina policies as well. So they rescinded their decision to involuntarily withdraw a 6-year-old Latino student for allegedly throwing a tantrum, according to a settlement agreement between the school and the parents. The SPLAC appealed the school's decision to expel the student, stating, listen closely, stating that it violated the student's due process rights and was an excessive response to a routine disciplinary issue in which no one reported serious injury. That whole statement right there spoke volumes. That is the terminology. Lawyers are using the wording student due process rights. That is big. I need for you to understand how big that is. We're going to come back to that in a minute. The school accused a 6-year-old of hitting his physical education teacher for taking his Pokemon card. While the appeal was pending, the court for the parties engaged in constructive settlement discussions, which resulted in a mutually agreed resolution to the matter, and the child was allowed back in school as part of the agreement. Also, as part of the agreement, the school system agreed to place the student in a different first grade class with a different physical education teacher. The school also will investigate whether the student was bullied and assess his needs for an IEP, an individualized education plan. In addition, the school system attorneys will review the student code of conduct to ensure that it adheres to due process requirements. Okay, so a 6-year-old hitting the teacher for taking his Pokemon. They wanted to have the student removed from the school, expel the student. When you expel, it's not suspension. You expel means the student can't return. So right here, we're getting into, and I believe we talked about it before, capricious and arbitrary conduct. When the crime does not fit the time that you have, the crime does not fit the time, when it's an extreme punishment for an act, and it's just unreasonable. So the lawyer stated that the student's due process rights were violated because there was an excessive response to something that was kind of minor. So your excessive response, a 6-year-old hit a teacher, you're going to expel them. They can never come back to school in your district. That's excessive. And they're saying that it was a routine discipline issue in which no one reported serious injury. The teacher didn't have a bloody nose or, probably nothing, a 6-year-old, nothing happened. So you're going to do that when there was not a serious injury and it was extremely excessive. So they won the lawsuit behind closed doors. They talked. School system probably realized that they didn't have nothing to work with, and they settled. And that that school had to do a lot of revamping. So that is, again, another case of due process, and that happened just last year. All right. So let's look at a scenario. This is something that if you're going to be in the school system at some point, you are going to experience a physical altercation between two students. That's just, that's a rite of passage as an administrator. You're going to experience this. So let's start from the beginning and go to the end with this scenario to make sure you're doing everything that you should be doing in the process. So you're busy doing your thing. All of a sudden on the radio, you've been called to room 106. All right, so radio and the incident. First of all, the front office has a radio, and all of my key people in my school have radios. When you have incidents, as an administrator, you need to have some type of code so that if somebody with the radios by students, they're not just talking, you know, a lot of stuff and getting information out that shouldn't be out. So you may have, you know, code blue, code red. If you do that, though, students are smart. Within a week, everybody's going to know what the codes are, what red means, what blue means. So what we do is we just say team emergency in 106. That can be anything. That can be someone fell out, fainted. That could be, you know, someone got sick. That could be a physical altercation. Emergency means whatever you're doing, stop and go. So that's what you do. You stop and go. So you arrive, as does your SRO, your AP, your school counselor, and custodian. Okay, why them? Make sure when you have crisis situations, you have a team and everybody knows their role for each type of situation that you have in your school. Okay, so for instance, your teachers play a role. The teacher must clear the scene by taking all the classroom students to the cafeteria or the convocation area or a designated safe space. Teacher has to make sure she gets the kids out. You can't have kids around in an unsafe environment. She has that role, or he has that role. The admin and SROs separate the students in conflict to take them to isolated areas. It's very important for you to remember that your SRO, or school resource officer, is your support. They will never be the leader of a situation unless there is a gun. Then of course, you know, I'm like, okay, I need you to take that because that's a gun. But if it's a fight, altercation, fussing, they're there. You're getting the students, pulling them apart, taking them to separate locations. School counselors, my school counselors show up. They scan the scene. In this lovely age, we have students that have their phones. They're like, yes, I can do Snapchat, TikTok. I can put this on Insta. So they're going to be pulling the students who have recorded this on their phones. So if they see phones, they're pulling the students because we need to get that off the phones. They're also pulling students that may have more knowledge of the situation, like the best friend of the person that fought. More than likely, they're going to know some things. It's going to be responsible for my witnesses. They're going to do all the witness statements for everybody else. That is a very important part. Witness statements. My custodian is going to show up. Why custodian? Because he's got to clean the scene. You've got to make the environment safe again. So furniture, equipment, if it's damaged or soiled, it has to be cleaned. Is there blood, throw up, any other bodily fluid around, medical stuff or physical stuff? You know, you have to make sure that you have a custodian that's going to, your crisis response team, whether it's in-house, like a fight, or whether it's a school crisis like a bomb threat or natural disaster, you have to be sure that your team knows what to do, how to do it, and when to do it. So this team was my in-house team. All right, so immediate actions. Immediately, you're going to assess for injury. That's not going to take too long, but you need to make sure to avoid a lawsuit that if someone needs medical attention, if one of the students need medical attention, you get the medical attention. Let me say that one more time, because you don't want the parent, their student shouldn't get suspended for fighting. If their student starts limping and their whole ankle is almost dislocated from their foot when they come and you did nothing, oh, the parent, they're going to have a field day with that. So you make sure you assess for injuries. Is EMS needed? An ice pack, a Band-Aid, whatever's needed, make sure you get the student what they need. Contact parents immediately. Once the students are separated, my front office person contacts the parent, and they do it a very general statement. They'll say, Mr. and Miss Brown, please come to XYZ school. Your student has been involved in an altercation and the principal would like to meet with you. That's it. That's all they say. And the parent will need to come. My front office person does not give them any details. Depending on what happened, the front office person shouldn't have extremely a lot of details anyway. So she knows that there was an altercation. That's what she knows. That's what she tells the parent. So once the parent knows, you are at an accelerated timeline to complete your whole investigation. You're looking through those witness statements. The parents are on the road coming. When they get there, it would be wonderful if you could be finished. Sometimes the parents have to wait, but you need to take the time that you need to complete the investigation. So with the statements, students involved in the incident, as well as identified witnesses, including the teacher and other staff members, need to have a written statement submitted to you. This is a part of the due process, the students' due process. They need to write a statement. They need to tell their story. Even though you ran up on them and you saw that he was punching, you're going to have to listen to him say, oh, I was just trying to defend myself and I was scared. Listen, you got to listen. That's their due process. Listen, let them write it down. You have to take that into account. So this is the heart of your investigation. If you are not there at all, you have to depend on the witness statements to devise your consequence. So if you have adults there, teachers there, you're relying on all of that to help with your final decision making. Okay, so in the investigation, collecting and receiving the statements and evidence. I'm not going to get into the meat and potatoes of the intense investigation because there are numerous factors that must be considered. What's the history of the two students? What led to the altercation? Who initiated the confrontation? Was the other student fully engaged in the fight, or were they actually trying to get away? Because that's going to make a difference if you saw two people going back and forth, as opposed to you see one student kind of pushing and then running, trying to get away. That's going to make a difference as well. So be sure to listen again to each student involved and give them the opportunity to plead their case. Yes, the due process summary. Thank you. Another key component that must be addressed is the recovery of any type of weapon. If there is a knife or mace or gun discovered, then your investigation and this is going to take another whole turn. Law enforcement is going to become more involved than if it was just a fist fight. So you have to remember that. With reasonable suspicion, you can search students. And you'll also review the video footage. So what Dr. Lamb put up here, the due process summary, process must be announced in the disciplinary data manual and the district code of conduct, yes. Right to informed of the charges against them, right to hear the evidence, the witnesses, yes. Right to respond to the charges, right to present witnesses, yes. And I did not clarify that. If you do have your students and you have one student that has a fight, that was in the fight, and then your other administrator has another, and the student you're with they're saying, all you have to do is ask Jane. She knows the whole story. She knows what the girl said before then and what she did. If they're like persistently, you need to call Jane. You need to call Jane, and the counselor or someone needs to get Jane's witness statement. You definitely do that as a part of their due process. They can call witnesses. Think about court. Court, you have the person, then you have the witnesses. It's the same difference in the school system. That is a part of their due process. Dr. Lamb, did you want to add something to that?
Make sure you separate the witnesses always.
Yes. Yes, always. Have plenty of rooms. Okay, so once you have your parents, let me see. How do we get back?
You can go ahead and start your share again. I'll stop my share.
Okay, all right, got it. Okay. Okay, so reporting, you're going to report to the parent, of course. You're going to report through Power School to the district. And depending on what it is, you're going to have to get on the phone immediately and call if it's an extreme situation. Don't just put it in Power School. And then if it's extreme again, you're going to report it to law enforcement. There are 16 reportable acts. You've got to report them to law enforcement if it falls into that realm. And law enforcement, I've had it where law enforcement would give me a case number. There's a place on our discipline form, our suspension form, that says, did you have to report this to law enforcement? If you did, what is the case number? Who is the officer? Just for their records, so they'll know what happened. And again, the state wants to know that the policy was followed. They need to know that you're following your policies, well, the policies that they've implemented. So you also reporting, I didn't indicate this, but depending on what the situation was, you may also have to inform your school community through a robocall. If it's a simple fight, probably not. If it was a gun that was found in the classroom and they were in a fight and the person pulls out the gun, and then you're going to probably need, some students might have been traumatized. And the thing you don't want to happen is for them to go home and tell their parents, there was a gun in my classroom, and the parent didn't hear anything from the school at all. So make sure you let parents know if there is a situation that could affect their child in the school setting. Now, remember that once you're speaking to the parents, when they come, that they are not privy to certain things, like the names of any other students involved, or the names of the witnesses, or what a certain person said. They're not privy to any video footage showing other students. So in essence, although you may inform them that you've reviewed the camera and saw their child initiate the fight, they cannot see that footage. The parent can appeal to the district, who may make attempts to redact portions of the video related to the other students prior to letting the parents see it. But you yourself, you tell the parent, no, FERPA, you can't show other people's kids to a parent in this type of situation. So just remember that, and let the parent know, I'm not going to show you them, and I can't show them you. So nobody gets to see the video footage because other students are involved.
How may I help you?
I'm picking up a prescription.
What was the last name?
Dr. Griffin Jordan, you'll have to unmute. I had to mute everybody.
Okay, no problem.
All right, before we go any further, I want to point out something that Dr. Griffin Jordan said there. You can't tell the other parent what the other kid got in terms of discipline either, because that's the first thing the parent will want to know. Well, you gave my kid 3 days ISS or 3 days OSS. What'd you do to the other kid? That's a FERPA violation. You can't talk about the other person's child. Now that's what parents will get the maddest about and press you on the hardest, but you cannot do that. You can't discuss what discipline was done to the other kid, even if you gave them the same. That'd make parents happy, but you can't. Your job's not to make parents happy, because that very parent will turn that around against you. So make sure you understand FERPA law says that you can't be disclosing information on other people's kids. You can't show them on video, but it also means you can't talk to one parent about what the discipline you did for the other one. That's the most common mistake that administrators make. Now, the second thing is I want to highlight what Dr. Griffin Jordan said about administrators take the leads on investigation. And she also alluded to why. you as school administrators, your standard of proof is reasonable suspicion. You have much more latitude in an investigation. Police, their standard is probable cause, which is much more restricted. So you can't just turn it over to them because they can't do the things that you can do. But you can't just throw them under the bus anyway. But again, to get to the bottom of things, you have a lot more power in that schoolhouse than the policeman does. You got to understand that. So that means that you always have to take the lead. You can't sit back and be secondary because you only have to have the standard of reasonable suspicion to search or do whatever you want to do. The policeman has to have probable cause, and that's a much tougher standard. So make sure that you understand that.
Okay, so we have finished our investigation. We've talked to all of the witnesses. So now we are putting our document together because we have to give the parent some suspension documentation, and we have to report to our district and the state, and we have to keep documentation in Power School. So if your district does use Educator Handbook, this is something, what it looks like for your new incidents. It has everything as you're looking up here, the date, the time. This is the person that reports it. It's the school principal, location, classroom, subject, math, arrangement, seat work, group work, transition, whatever the arrangement during the time of the incident was. Choose an offense, so it would be physical altercation, provide a description. This is where the meat and potatoes goes. You need to make sure you are extremely objective. Only the facts go here. If you are quoting something that a witness, maybe the teacher or someone said, you need to quote it as it was said. Make sure you are objective, because in this description, this is what is going to be reported. This is what the parents will be able to read. So you cannot say, Johnny has been irritating me for the last 2 weeks, saying that he was going to fight someone. And you know what, now he finally got in a fight like he warned me. And you can't do that. You can't say, you know, you can't be subjective, pretty much. Just make sure you have the facts, and make sure when you reread it, that the parent and the superintendent and anybody else that reads that will see that you were fair and objective in your description. No subjectivity in that description. At the bottom, you can see adding the offender. After that, you will see the victim. If there is a victim, the action taken would be under that. That would be your consequence. It would range from anything. It's a whole list of consequences, from restorative practices, from in-school suspension, conference with the student, parent meeting, ISS, OSS, all those actions will be listed, and you will just click on everything. One best practice that I would like to share is whenever you have an incident, regardless of how severe or minor it is, one of the things that you need to always put in as an action is the student conference. Whether the student cheated, whether the student got in a fight, whether the student skipped school, someone, either the administrator or teacher, needs to have a conference with that student. If you're writing it up, the student needs to know. So that conference, always have a conference with the student. So after all this, you're going to print up your documentation. The Educator's Handbook will print you up an office referral, your suspension documentation. Make sure you give the parents the code of conduct. Please make sure you give them the code of conduct so that they can see what policy their student violated. They need to understand that you are not making this up. You can show them exactly where you're getting your standards from. If you are recommending long-term, if it was so severe that you're recommending long-term, you must also give that parent the right to appeal form that allows them to appeal your decision to recommend their student for long-term suspension. You have to give them that. I love Educator's Handbook. What we do, the district has us once a week to export, or at least once a week, we do it more, to export what you put into Educator's Handbook, export it to Power School. If it is an extreme situation, it needs to be exported immediately. But everything that's exported in Power School is listed, and it is reportable. It is reported to the Department of Public Instruction. Okay. So questions, thoughts about student rights and due process. I'm going to stop sharing now.
I have a question. Are parents given that right to appeal for any out-of-school suspension, or does it have to be a specific amount of days that they are being suspended for?
I wrote that note down. Parents can appeal any disciplinary action to the area superintendent, assistant superintendent, the superintendent, the school board, and then can go to court. So any consequence that you levy can be appealed. But the law says is if you are asking for a 10-day suspension with an exclusion or disciplinary placement, you have to give them the appeal form. That's what Dr. Griffin Jordan was saying. Now, they have the right to appeal any decision you make, any, A-N-Y. Even if you give them lunch detention, they can appeal that. That's why it's so important to get that description right when you write it up, because you might as well assume that every time that it's going to be appealed. Every time, no matter how minor the infraction or how minor the consequences, assume every time it's going to get appealed. That's why it's so important to write it up. Now, as crazy as this sounds, the biggest problem that I used to have when I was in charge of all this for the largest district in the state is people would write up one thing and categorize it as something else and then give a third different consequence. And then you got to be consistent. If you wrote it up as a fight, you have to classify it as a fight and you have to punish it as a fight. But what I've seen folks do, they'll write it up as a fight because they don't want that on their records. They'll put it in as disruptive behavior, but then they'll give them the same amount of time as a fight. Well, disruptive behavior does not carry a 5-day OSS. And then when it goes to appeal, you get killed. You just absolutely get killed because you have violated the standard of capricious. You gave more punishment than the crime, but you said, but he was fighting. I can give 5 days, but you didn't tell us it was a fight. You said it was just disruptive behavior or aggressive behavior. You got to be consistent all the way through with your write-up, what you actually, which of the state laws you be aggressive behavior or you be fighting that you select. The state says this is what they are. It's in that disciplinary data reporting manual that's under, let me share my screen. Please remember, we've got all this categorized for you. This document's there as well. So if we go to Zoom session 5, we've got incident reporting, which is basically it shows how you would go enter into Power School. We've got a code of conduct here. That is, again, that's the interpretation of the state manual. Here's what must be reported. Here's the state manual. Here's PBIS. If you're a PBIS school, you got to document your steps in that. Violence in school presentation that I did years ago. The law again, antecedent behaviors, the little things become the big things. If you let them go, you don't address them, they become the big things. Bullying prevention, that goes back to that manual. Due process summary, and what happens if you don't report. That's what we've kind of got it categorized here, right down the line. But you can see, you can't make